Good afternoon, everyone. My name is Lisa, and on behalf of New York Farm Bureau, Cornell Ag Workforce Development, and Farm Credit East, welcome to our webinar on preventing sexual harassment in the workplace. We're happy that you have all found time in your busy work and holiday schedules to take part in today's webinar. Our thanks go to Farm Credit East for hosting our webinar today. Just a few housekeeping issues before I turn things over to Elizabeth and Richard. Participants will be muted, but you will have the ability to type questions throughout the presentation, and Liz and Richard will be answering questions at the end. So as questions occur to you, click on the red arrow in the upper right-hand corner of your screen to expand the GoToWebinar control panel. That will display the text box to type in your questions. At the end of this webinar, you will receive via email a short survey, and we would really appreciate your answering those questions. The survey should only take about 5 minutes or less. It may appear that we're moving rapidly through the slides, but there is a lot of information to cover today. Tomorrow, you'll receive an email directing you to Farm Credit East website, where you can find the recorded presentation as well as the slides. And now, I'm pleased to turn the presentation over to Liz and Richard.
Good afternoon. This is Liz Frybush at Farm Bureau, and I just wanted to cover just one quick housekeeping item following up on what Lisa presented. Because I am an attorney, and I just want to make sure that you understand that this presentation is not intended to be legal advice. It's general information only. Individuals will need to talk with their own private attorneys as to how this type of information will affect your particular ag business or farm. But just getting started on the next slide, how did we get here? Okay, thank you. New York State, in its budget process last year, approved a new provision providing for sexual harassment education and training. It requires all employers to have a sexual harassment policy, and this legislation mirrors other laws that have been proposed in other states related to the Me Too movement, which we've all seen so much about in the news, trying to address the issue of sexual harassment in the workplace and its prevalence. The New York law requires, as I mentioned, that all employers after October 9th, 2018 must have a sexual harassment policy. And this covers all employers regardless of size. So even if you only have one employee, you need to have a policy. And part of that policy, you're required to have training for your employees on an annual basis. The first round of training doesn't have to be completed until October 9th, 2019. So employers have less than a year now to complete that training for their employees. So you already should have a policy in place, and you're starting the process now for getting that training together for all your employees.
And this is Richard Stupp with Cornell's Ag Workforce Development Program. And I'm glad to be here with you today. And thanks to Farm Bureau and to Farm Credit for organizing this and letting me be a part of it with them. So why take this seriously? Actually, if you look at that slide, I'm going to start at the bottom because in many ways that's the least important reason, because it is the law, and as an employer, all employers need to comply. But let me then jump to the top. Because it's a problem. Sexual harassment is present in the agricultural community. We've seen it anecdotally, and statistically we'll see some evidence of the prevalence of sexual harassment in a few minutes. But I also wanted to focus on these two items in the middle. First of all, because it's good business. Successful businesses today have to have excellent employees and great teams. And harassment of any kind, especially sexual harassment, destroys morale, destroys people, and it really destroys teams. So if you're going to be successful in the long run, you've got to eliminate these kinds of harassment from your business, especially sexual harassment. And the last thing, it's the right thing to do. Our employees in agriculture deserve to have a place to work that they can be free of fear. So back to you, Liz.
Thank you, Rich. Even without the new law, sexual harassment and its prevention has been an issue for businesses and of concern for businesses for many, many years. Unfortunately, there is a great prevalence of sexual harassment in the workplace. The Equal Employment Opportunity Commission estimates that in 2015 alone, that from their office, they recovered over $164 million for workers alleging harassment. And that's only employees that filed claims with the EEOC. It doesn't include civil suits that were filed privately or other negotiated settlements in sexual harassment situations. So it can be a very, very expensive issue for businesses, even without the new sexual harassment prevention law in New York. Next slide. You know, sexual harassment is very prevalent, and we'll see some statistics on the next slide regarding, you know, just specifically for women who have reported sexual harassment. 25% of women in the workforce have reported experienced some sort of sexual harassment, and 40% of women experience sexually based behaviors, and you can see they could be sexual coercion, sexual attention of some kind, and half of women have reported experiencing some sort of unwanted sexual attention and so forth. So it is quite a prevalent situation. It's not something that all people are willing to talk about. So these statistics might come as a surprise to you. So it's just something that we all really need to be aware of if this isn't an area that we've had any professional experience with. So having an understanding of what the situation is in the workplace is really important. All businesses are different, all circumstances are different, but we really need to be aware that sexual harassment is occurring in the workplace, and it is more prevalent than we would like to believe.
And so the prevalence of sexual harassment, then I wanted to share a few stories, a few anecdotes, because one of the key points that we need to get across today is that sexual harassment is not as simple as you might think. There's a lot of different ways that sexual harassment can occur, and some would be very obvious in an office setting, some in a farm setting might be a little bit less obvious, but we need to explore that in a lot more depth, and we will as we continue in this presentation, but that's a key part of it. So anecdotally, just a couple of things that many of us who've worked in agriculture will have seen some cases, and I wanted to share that since this law came out, I've talked to a lot of folks working in the industry, and I've heard a lot of stories that has convinced me that the prevalence of sexual harassment is a lot greater than what I ever knew before in the industry. But it's things like women agribusiness representatives who show up on the farm and have been harassed, and sometimes it may be that the farmer or whoever is there that they encountered on the farm maybe didn't intend it to be harassing, but nonetheless, those behaviors are demeaning to women at times, and can certainly be a situation that is a harassing situation. So we need to be more aware of that and starting to address those issues. Whistling and catcalling, it certainly happens in all different situations, and it certainly takes place on farms. We have a lot of different cultures working on farms today, and we need to get everyone recognizing which behaviors are appropriate and which ones are not. That third bullet then is a situation that I worked with, an individual farmer who had this situation on his farm where one employee was trying to get the attention of another employee and started to basically block her passage and try to talk with her and kind of corner her in parts of the barn. Clearly, sexual harassment, classic behaviors there. Fortunately, in that case, the farmer dealt with it right away and took a very appropriate position on that and was able to resolve it immediately. But these are just a few of the examples, and we'll continue to explore farm-specific examples that illustrate what sexual harassment is in more detail. Next slide, please.
And sexual harassment is a form of discrimination. And the top of the slide says it's been around a long time, and that talks about two things. Sexual harassment has been around a long time, but laws that address sexual harassment as a form of discrimination have also been around and evolving over time. One of those is Title VII of the Civil Rights Act of 1964, which is a federal law. And we also have the New York State Human Rights Law, which sex discrimination and sexual orientation discrimination was added to as well. And both of these laws have evolved over time to include various types of sexual discrimination. And I don't think a lot of folks really think about sexual harassment being a form of discrimination, but in the workplace it is, and that's how the law treats it. So that it's something really to be aware of and to really think about when you're thinking about sexual harassment, that it is discriminating against folks based on their gender when sexual harassment is ongoing. We can move on to the next slide. And again, sexual harassment is a form of sex discrimination, and it includes a broad range of harassment. It's not just sex. In New York, it's also sexual orientation, gender identity, and transgender status. And sexual harassment, again, is conduct that's of a sexual nature or directed at someone because of that person's gender. So, I mean, that's a very broad description of what sexual harassment is. And while it's impossible to give every possible example, the next slide will address what a few common examples are in the workplace. Rich?
Right. Thanks, Liz. And these, again, some examples here, just to get you thinking how broadly and how differently some of these things can be. So yeah, certainly verbal, visual, or physical. Certainly offensive remarks or jokes that take place, and that's the key. They have to offend the other person in the workplace. Obviously, unwanted touching or groping, when that behavior is unwanted by the person. So this is where it gets very difficult to sort out. Some things are obvious, but a hug among a couple of people may be very appropriate, and this law is not intended to eliminate that where it's welcome behavior from both parties. But in other cases, it could be very much unwelcome by one of the parties, and in that case, especially when that behavior is repeated, that could be sexual harassment. So those are things that some of the subtlety that comes out. Certainly coerced sex acts, and coerced means that someone in a position of authority or power uses that in some way to gain some sexual favors. The next one, request for favors of a sexual nature, the example of asking an employee to dig coins out of the supervisor's pants pockets and things like that. Displaying pornographic images or cartoons, or the calendar that ends up contributing to an atmosphere of harassment. Comments, whether complimentary or derogatory about a person's gender or sexual preferences, it's best to just leave those sort of comments out of the workplace as much as possible. Just leave them out. Obviously, sexual gestures would be very unwelcoming, and I already mentioned whistling or catcalling. So just to try to give you an idea with some practical examples here of things that could easily be sexual harassment. And we need to think about two aspects of that. Harassment is illegal when it's so frequent or severe that it creates this hostile or offensive work environment. So sometimes something very minor that happens one time doesn't necessarily create a hostile environment. But when it repeats, when it's just the culture that there's sexual innuendo or there are sexual in nature comments, or there's gender-based comments that end up creating a situation where people feel that they're unwelcome or that the workplace is difficult for them to be in. And again, this is in the perception of a person working there who's feeling that. So others, it doesn't matter if others feel that, well, they should be accustomed to that or they should be used to that, but I know that's not the standard. It's how people feel. If they feel that hostility directed toward them because of their gender or because of other sexual matters. The other part then is quid pro quo, and that's certainly a legal term, and the whole idea is trading this for that. So trading, in this case, again, someone in a position of authority who could potentially offer a promotion or a raise or something like that in exchange for some type of sexual favors. And that would be quid pro quo, and it is definitely illegal.
A harasser can be a supervisor. That might be something that people typically think about, but it also might be a coworker who's on the same work level as an employee. But it also might be a client or a customer or someone who comes to your business, to your farm, and interacts with your employees. You might have an employee who is harassed by one of those folks, and that's something you really need to be aware of, that it's not just managers or supervisors that can be an harasser. And also, it's important to keep in mind that with sexual harassment, it's not just men harassing women. You might have situations where men harass other men, women harass other women, or even women harass their male coworkers. So it is something that's quite broad, and we need to prevent being caught up in the stereotypes. We hear the Harvey Weinstein type situations. Those aren't the only types of sexual harassment that are out there. Rich went through a long list of different types of harassment. The types of folks who can be an harasser is just as long. So being aware of all that is very important. The next slide here addresses a couple of issues before we get into the very specifics of what a sexual harassment policy should look like. We wanted to mention a couple of attributes of the statute. If you have employment contracts or you use an agreement to settle a sexual harassment complaint. And these aren't something we're going to focus on to any great degree, but we want to mention them because they are part of the statute. First of all, if you have an employment contract, within that contract, you can't require mandatory arbitration of sexual harassment claims. Some employment contracts in the past have done that, and that's no longer allowed. And also, with regard to sexual harassment agreements that settle sexual harassment claims, those can't have a non-disclosure provision. So unless the person making the complaint wants it for their own benefit. And then there's some provisions for very specific timelines when you make the agreement that the person making the complaint has a full 21 days to consider that resolution, and then they need to have some time to revoke that permission after they sign the agreement. These are very similar to what are in agreements settling things like age discrimination and so forth. So these are common within the employment situation. They don't apply in all circumstances. There's two very limited exceptions, and those relate to collective bargaining agreements and agreements that conflict with federal law. So these types of things will affect most employers if they want to have an employment contract or have one of these agreements settling a sexual harassment claim. So moving on to the employer's policy. And at the beginning of the presentation, we talked about the state law requiring that all employers have a sexual harassment policy. And the state is very particular about what that policy needs to include. And the policy that an employer puts in place must conform with the guidance that the state has already provided. And on the state's website that addresses sexual harassment, they have a model policy. And this is a great starting point for employers who don't already have a sexual harassment policy. It's very specific. You really only need to insert your business's name, but it's very important that you review what that policy needs to include, and you determine on your own whether or not you think that this policy is what you want for your employment situation, or if you would like to have a policy that's specific for your business. But in all circumstances, if you have a policy that's different than the one that you find on the state website, that policy still must meet or exceed the minimum standards of the model policy. And we'll spend some time now just going over what some of those very basic provisions of the model policy are, so you can get an idea of what what your policy would need to include. First, there needs to be a statement in the policy that applies to all employees or applicants for employment, that it applies to interns, even if they're unpaid, and that it applies to contractors or anyone doing business with you, regardless of their immigration status. So that's something that needs to be a statement within the policy. And for all employers, that'll mean something a little bit different. You might not have interns, but you have contractors that come on your farm or to your business that interact with your employees. So you'll have to think about, what does that mean exactly for your business, for your farm? You have employees? Do you have consultants? Do you have customers that come to your business? And basically anyone who interacts with your farm or farm business. So again, and then going over just a few of the basics again of the policy must specifically prohibit sexual harassment, and it needs to be a very clear statement. And then provide examples of prohibited conduct, those things that Richard reviewed earlier. And you'll want to use ones that are a better fit for your work environment, things that you can see happening on your farm or at your farm-related business. For example, I used the Harvey Weinstein example earlier. You will not want to use one related to the casting couch, so to speak. You'll want to have something that's specific for your business and that resonates and is understandable for your employees. And part of the policy must include information about the federal, state, and any local laws that impact sexual harassment, and what remedies are available to those employees or anyone impacted by sexual harassment at your workplace. This allows employees to better understand the legal framework that supports the policy, and then provides them with some additional information of what they can do if they're being harassed. The policy also needs to include a complaint form. Employees need to know if they're being harassed or they see another employee being harassed, how do they report that? How do they get that information to a supervisor, to a manager? So that policy must include a copy of the complaint form. And the policy also needs to describe the procedure for the timely resolution and investigation of complaints that provide due process for all the parties involved. So that policy will need to tell what sexual harassment is, give examples of the conduct, include the information of the statutory framework, provide the complaint form, and provide for the procedure for investigation and resolution of complaints. So it takes the sexual harassment situation from start to finish. So that's part of the whole process. So, and moving on to the next slide. As I said earlier, you need to inform your employees through the policy what their remedies are, and if they're being harassed, and where they can go to get a resolution of that complaint. The policy will need to talk about making a complaint to the employer. It'll also need to talk about letting that if they can't go to their employer, they don't feel comfortable going to their employer, that they can also go to the State Department of Human Rights or EEOC. That's part of that model policy. And it gives those employees who, especially for small employers who might only have 1 or 2 employees, a place to go with a complaint if they don't feel comfortable going to their employer, because employees might be concerned that they may be retaliated against. But the policy will also need to state that harassment is a form of employee misconduct, and there could be sanctions or some sort of discipline for employees that engage in that behavior. And depending on the type of behavior, how egregious it is, that discipline or those sanctions will differ. I mean, for someone who has a single instance of whistling at another employee would be very different from one that sexually assaults another employee. So but employees need to know that some action will be taken where sexual harassment is found to have occurred. And also, it's also very important to know that with managerial and supervisory staff, your farm managers, employees that are crew leaders that supervise other employees, that they may be subject to discipline if they knowingly allow that kind of behavior to continue. So if your managers or supervisors know that harassment is occurring and don't do anything, that creates a liability for the employer. So just be aware of that. And we'll talk about that even more later. And then finally, the policy needs to talk about retaliation. And that's where an employee, a negative employment action is taken against that employee for making a complaint. Retaliation could be demotion if they make a complaint, that their hours are cut, they're given less favorable hours. They might be even fired if they make a complaint against someone for sexual harassment. So if someone makes a complaint, they need to know that they're protected from retaliation, or if they participate as a witness in an investigation, they also need to know that they're protected from retaliation through your policy. And I mentioned earlier with regard to the complaint form that all policies must have one, but this gives employees a way to let their employer know that something has happened, that they want to make a complaint. And they need to be encouraged through the policy to complete the form and submit it to whoever at your business has been designated to receive those forms. And that would be something you would include in your policy, who would receive a sexual harassment complaint form. And part of the program is also letting them know where they can find a complaint form. They should have the one come with their policy, but if they lose it, they need to know where they can find one. So we can move on to the next slide. Oh, and since since employees may speak different languages, we want to make sure that the policy and the training that they're given is in the language spoken by your employees. So if you think about it, that makes the policy and the training much more effective. You want to make sure that they understand what the policy is and how to address situations that involve sexual harassment in your workplace. Model policies can be found on the state website, also in addition to English, in Spanish, Chinese, Korean, Russian, Italian, Polish, and Haitian Creole. For most employers in New York, at least farm employer, Spanish is probably the one that's of greatest interest there. But we did include a very specific link on the slide for where to find the policy when they're in the different languages, because it's not intuitive on the state website and it's not in the same location as you would think it is. So we just wanted to make sure you had the very specific link for that so you can access it more easily. On the next slide, we'll see a sample sexual harassment poster. Part of the state policy is that you include a poster related to your sexual harassment policy. And there's a lot of words on the screen right now. And basically, it's just the really core elements that sexual harassment is prohibited, but it includes information such as where a complaint form might be found, where the complete policy may be found, who a complaint should be given to, and what that contact information is. It's basically just a quick summary of where to get a policy if you don't, or excuse me, the policy and the complaint form if you don't have one on hand. So your employees can always get one if they don't have one. For some employers, that might be an office where they can get a paper copy. You might, if your employees have computer access, you can put one on your system where they can access it from their computers. So there's different ways to make those available. Employees just need to know where to go to find those. And
okay. Sorry, Liz, go ahead. Okay, I'll jump in here. So up until now, Liz has been focusing on the policy. And just to internally recap here just for a moment, there's two requirements in this new legislation. One is that employers have a policy, and that's what Liz has been talking about. And so you're already supposed to have a policy in place as of October 9th of this year. The second component then is that employers train their employees on sexual harassment prevention, and that is required training to take place for all employees by October 9th of next year. And let me pause just for a moment. So we have a choice, and every ag employer in the state has a choice about how they're going to handle the training. So we can complain about it, and we can complain about some burdensome regulations, or we can step up and lead to make our industry safe for everyone. And we've already talked about how sexual harassment is there in agriculture, just as it is in every industry. And I expect that we as an industry are going to pick this up and do a great job for our extremely valuable employees. Because our employees really do deserve respect and not harassment. So let's make the right choice. So on training, the state does require several features of the training that you provide. So all employees have to be trained. New employees that come to work for you, it doesn't say exactly when, but it should be as soon as possible. That's what the legislation says. There is no exemption for employer size or for farm employees. So those two areas that often have exemptions in other laws do not apply here. So even that kid that comes and mows grass for you in the summertime really should be trained in sexual harassment prevention. And then certainly training should be provided in the language that the employees understand. And just one quick comment on that. On the state's website, what you do is, and the link that Liz provided is the best way to get to the multiple languages website, but it's all the way at the bottom of the page. So if you're on the state's other pages, if you scroll all the way to the bottom, you'll find the links to the translations of the training materials, the policies, and so forth. I've had a lot of questions about that in recent weeks. Let's go to the next slide. So again, every employee needs to have that training, and but there are occasionally some other people on the farm who are not employees. And that could be, in some cases, interns or volunteers. You think of perhaps some community-supported agriculture or other types of operations that do involve interns for educational credit or volunteers of some sort. The law does not require those folks to be trained. However, it does require that they get a copy of the policy so that they know that the employer forbids sexual harassment. But I want to talk a bit about another group of people. So, and this is not new to this legislation, but an employer is responsible for protecting their employees from sexual harassment. And so that can be harassment that comes from other visitors to the farm. So if a service provider was coming to the farm, or a customer was coming into the business and they were harassing employees, then you need to deal with that. You need to address it. And I'll just share very briefly a situation when I was an agribusiness manager, and we had a customer that would come into the business way too often for what his business required. But his goal was to talk with one of the female employees, and it progressed into a harassing situation, and just got worse and worse, as these situations often do. And when she let me know about it, I had to go and address that situation with the customer, and it was an uncomfortable conversation, but he got the message and stopped coming into the branch. But it was one of those things where it's just very important for employers to think about it from that perspective, that we need to protect our employees. So on with training in the next slide, please. So some goals for us to think about are to communicate what the organization's, what your farms or your business's expectations are. You know, when we communicate our expectations clearly, believe it or not, people are a lot more likely to meet those expectations if they are clear. And we want to build that culture where employees do feel comfortable to speak up for themselves and for others, to know that you're not going to get in trouble because you've complained about a bad situation. So that's the kind of trust in a culture at the workplace that we want to build. We also want to build a culture where people understand that people have different thresholds of tolerance, and what might be okay for one person is definitely not for another. And that situation needs to be respected. Just because someone feels more threatened or less comfortable about sexual comments or about explicit jokes or posters hung up in the workplace is not a reason for them to be punished. The training needs to explain how to make a complaint, and that complaint form that Liz talked about. It needs to assure employees that, you know, a complaint of sexual harassment won't be laughed off or swept under the rug, that it's going to be investigated. Ultimately, we need to put our training together in a way that's really going to eradicate workplace harassment. That's what our ultimate goal is. And so when we do that, we need to take it very seriously. So training also has these requirements that the state has laid out, and the main bullets here really are state requirements. So first one is that it must be interactive. So you can't just park someone in front of a computer or TV and watch a video and have it be done. It has to have some level of interaction between the trainer and the employee being trained. So it could be web-based with some questions. So in this case, if the employee has to select some answers at the end of a web-based training so that we know that they were awake and paying attention and so forth, that's interactive. Web-based with an option to submit questions or receive an immediate or timely answer. As long as they have a way that the trainer could be remotely based, but as long as the employees have a chance to ask some questions, that could be interactive. It could be a live training, which it might be in many cases. And I view a hybrid of some video and some live question and answer as the route that many people will choose today. In that case, we'll perhaps show a video, and then the presenter asks some questions or facilitates the conversation. It could be web-based or in-person training with a feedback survey for employees to complete. A lot of different ways. But just watching the video is not interactive. We've got to have a chance for the employees to be fully engaged. And then the last point there is that, on this slide anyway, is that explanation of sexual harassment, what it is, has to be consistent with the guidance that was put out by Department of Labor and the Division of Human Rights. So if you're using the training, the policy and training that is on the website put out by the state, then you will meet those definitions. Let's move to the next slide. Training must include, again, with the state requirements, include examples of conduct that would be unlawful sexual harassment. Just like Liz and I have been talking about earlier, your examples should be shared. Include information about the federal and state statutory provisions concerning sexual harassment and remedies available to victims of sexual harassment. So what is the law? That's what it's saying. What is the law, and what can employees do if they feel they've been harassed or witnessed harassment? Rights of redress is the next bullet there, and what can employees do in a harassing situation. And like Liz said, in some of these situations with smaller employers, some special arrangements may need to be made. Yes, an employee could go to the state regulators and make that complaint, but employers may want to think of some other alternatives. Perhaps it's the human resource consultant. Perhaps it is an attorney in the local town, a designated person that an employee could make a complaint to so that it can be resolved without it necessarily going to a state regulator. And then we'll talk a little bit more about the situation with supervisors, but that is a special case. And so I just want to highlight that, but we'll come to that in more detail. But supervisors or managers, anyone with authority in the business has special responsibilities when it comes to sexual harassment. We'll talk about that some more. Next slide, please. So you've got several options, and these are a few that I see. First one is that you, the employer, do the training yourself, or a designated person within the business, do the training yourself, use the provided resources, which we'll talk about in a minute. That's certainly a possibility. Use the video. So the state, if you've looked at the website, you'll find there are some videos on there. There's two videos, each are about 30 minutes long. These videos, it says right on the website, meet all the requirements except for the interactive portion. So it would be possible to show those videos and then have an interactive discussion with your employees. If your employees speak another language, I think you'll need to bring in an interpreter to work with you in that situation. But I think that you could meet the requirement in that way. I don't think that all the videos are available in all other languages yet, but that is coming very soon, I understand from the state. Or a third option, I think, is to use an outside training provider. And so certainly human resource consultants are out there. There are a few in agriculture who would be capable of doing that, even if they use the materials provided by the state. We've had some conversations at Cooperative Extension, and we do have personnel here who can facilitate this training, again, at this point, using the state's resources. But we are exploring opportunities for us to develop some materials that are more farm specific and might be more helpful that way. I will say that the videos that the state provides are about 30 minutes long. Each of them is 2 videos. These are resources provided by the state, and there's 4 pieces. I'll talk about the videos first. It's basically a person talking and some slides appearing on the screen. And a lot of the examples tend to be more appropriate to an office type setting. However, I think for now, they would do the job. It's just that if in the interactive portion, you get some illustrations that are more familiar for a farm situation, I think that would be extremely helpful. Some of the other resources on that page are a written document in Word and PDF. It's important that it's there in Word files because you can go in and customize that for your farm situation. Customize it, for example, of telling people who they should report to any incidents of sexual harassment. There are PowerPoint presentations available in both PDF and PowerPoint, so anyone should be able to use those. And there are case studies, which are rather detailed. There are 6 different case studies that really illustrate in detail a lot of the concepts that Liz and I have talked about so far. All these tools are available in multiple languages, particularly English, Spanish, and Haitian Creole, which it's most of our employees in the state.
Thank you, Rich. Now we'll talk a little bit more about the special requirements for supervisors and managers. And again, managers, supervisors, they might not be folks that you, or they might not even consider themselves supervisors or managers, but again, they do have authority at your business, on your farm. They might supervise an employee or assign work to an employee. So think about what that means at your operation, whether or not someone could be considered a manager. But again, they have special responsibilities, and they're held to a higher standard, I don't want to say higher, but a very high standard of behavior. And they have an obligation as a manager to report sexual harassment. So if they know that something is happening, or if an employee is being harassed, they need to report it, even if that employee doesn't report it themselves, because otherwise the employer won't know that that behavior is ongoing. And a manager, under the policy that we discussed earlier, could be subject to discipline if they know harassment's occurring and they don't report it and then take steps to investigate and stop the behavior. So that's something that's very important. They're expected as managers to model appropriate behavior. So they need to understand, and they need to be trained to understand that they need to model that behavior. So they need to set the standard for your other employees. If you have managers that are engaging in harassing behavior or not taking action if other employees are harassing, then the policy you have in place won't be effective. It won't protect your employees, and it won't protect you as an employer from complaints or from your other employees. And that can create liability for you as an employer and provide you with an opportunity to correct harassment. Because liability, especially with sexual harassment situations, if you nip something in the bud, it's much less likely that you're going to have an ongoing problem. If it's addressed, if you have harassing behavior, it's addressed immediately, it's minor, you can overcome and address those things. If you end up with a pervasive environment where you have a lot of employees who are being harassed, or employees where it's gotten to a very serious situation, it's a lot harder to resolve those situations with little liability for the employer. So you want to make sure that your managers are trained well enough to understand what sexual harassment looks like, what they need to do in the event an employee comes to them with a complaint, or if they see it occurring, or if an employee who's not being harassed comes to their manager and reports harassment, that they also need to take action in that circumstance. So that training for managers is incredibly important. And again, moving on to the next slide, managers need to report behavior even if someone isn't already complaining about it, because the employer will be held to what that manager knew. Even if the manager doesn't think the complaint is serious, or they think the matter is trivial, they still need to report it so a proper investigation can occur and appropriate action can be taken. Again, it's the training for your managers is incredibly important. And even if an employee says that they don't want a complaint to be made, the manager still needs to go ahead and report that to their employer so that investigation can occur, and so appropriate action can be taken. And managers need to know that if they'll be subject to discipline if they fail to report suspected sexual harassment, or if they knowingly allowed sexual harassment to occur, or for engaging in retaliation. And we went over that earlier. Retaliation is taking negative employment actions against an employee for reporting harassment or participating in an investigation for harassment. So it's very, very important that you train your managers or supervisors with these issues, because they're key to making your policy work. Without it, having the policy will not be effective, and your employees won't be protected.
So far, we've talked about the policy and training, but let's take a leap ahead now. And what if something actually happens? And so what are your obligations as an employer for follow-up? You might notice that the slide just changed. That's because this slide is directly from the state's training materials. And what it's getting at, I know that we've been recommending that employers, especially for timeliness reasons, can simply adopt the state's policy, put your business name into it, and put that into place immediately. If you've done that, just be aware that this is what you signed up for in terms of how you will respond to an investigation and correction of an actual sexual harassment situation. So on this slide, anybody engages in sexual harassment is going to be disciplined. Complaints will be investigated immediately, and employees may be required to cooperate in that investigation. As I said, you're supposed to customize this, and so you'll see the yellow highlighted area. All the policies and other state materials have the areas yellow highlighted where you should put your business name in, or a designated person that employees should go to report harassment. But here on this page, what is in that policy? An immediate review of the allegations and making error corrections, review all the documents and other communications, interviews, and finally the individual who complained and the person who the perpetrator of sexual harassment will both be notified at the end of any action that takes place or investigation. So next slide, please. We're going to jump into what should an employer do. Now, this is not really spelled out in the new training. The next several slides come from what has been expected for many years, especially from the federal EEOC Commission, about how employers should follow up. So this is some good practice, some good guidelines, not necessarily out of the new state laws. First of all, take action to protect the person making the complaint. These can be very serious situations, so you need to evaluate that right away. Does something immediately need to happen? Does a person need to be pulled? Does someone need to be pulled out of the work site or separated in some way? Protect confidentiality as much as possible. And number 4 there is a theme you'll hear in the next couple of slides, which is document. Document your actions, document your decisions, keep a written record because it needs to appear in writing or it never happened. These investigations are tough. A lot of business owners really struggle with interpersonal matters and emotions anyway, and you get into a sexual harassment situation and that just ramps everything up and makes it extremely difficult. So I recommend that before you go into an investigation, you need to have a plan and you need to stick to that plan in order to keep yourself from veering off in directions that are completely unpredictable. So, what's the scope of the investigation and what question are we going to try to answer there? What is the specific allegation? Who is going to investigate? Is this farm big enough or business that we have someone that can be relatively independent? Do we have an HR type person, or do we have a person that could relatively or reasonably, in an unbiased way, investigate this? The thought here is that can the farm owner really objectively investigate an allegation of sexual harassment against his son? So those are questions that need to be answered. Who's going to do this investigation? What evidence should we collect? There could be phone records, time sheets, social media might have some evidence out there, perhaps camera footage in some workplaces. Who's going to be interviewed in addition to the person making the complaint and the accused? Are there other people that may have seen the behavior, or maybe they can testify in the other direction? It's hard to say, but can other people offer their input about what did or did not happen? Prepare some interview questions in advance for both the complainant and the accused, so that you stay on track and get those questions answered. And I shared a website there again from EEOC that has some example questions. Again, document your actions each step of the way. And then conducting the investigation. Obviously, gather the evidence, conduct those interviews. And as I said, these interviews can be difficult. And if you're the person and you haven't done this you're the person investigating the situation, haven't done this before, there's going to be a tendency for everyone to want to rush through and get to the end as quickly as possible. I encourage you to slow down and to leave gaps in the conversation so that people can respond and formulate what may be some very difficult words that they need to say about a sexual harassment situation. So you need to slow down. Make a decision. This is not a court of law, and it doesn't have to be beyond the shadow of a doubt or anything like that. It's just the preponderance of evidence. Is it more likely to have happened or more likely to not have happened? And then document. You may not be 100% right in what your conclusion is, but you certainly want to document how you arrived at that conclusion. Once you've arrived at a conclusion, you need to take the steps for disciplinary action. So take corrective actions if it's needed and follow up. If warranted, take that action, and it may be just a verbal reprimand, or it may be termination, or it could even be worse than that. It might be referral to law enforcement. But you need to determine what that action should be. It could be a reassignment of workers, but be careful not to inadvertently punish the person making the complaint. So the person making the complaint ends up getting shifted to the night shift. It almost comes across as punishment because they've reported. Document your actions with that full and complete written report. Include all documents, summary of those documents that you reviewed, names and summaries of interviews and so forth, and your basis for your decisions. Then communicate with the person making the complaint about what actions that you took. And then last, follow up with that person over time to make sure that harassment hasn't continued, and go ahead and document that continued follow-up and what their response was. So there's a lot to do there.
I just wanted to spend a minute or so wrapping up. We have a few slides related to best practices, tips, and reminders. I only want to cover a couple of those quickly because we want to have a few minutes for questions. Just letting you know that volunteers and contractors aren't subject to the training, but they must be given the policy. Minor employees must be trained, but they can be given simplified training. And again, just re-emphasizing that supervisors must report incidents of sexual harassment, even if the employee does not, because that's really important. And also, Rich mentioned an example in one of the previous slides where it might be difficult to be difficult to investigate a family member. Just a reminder that even if your employees are family members, you still need to have a policy and you still have to do the training. It might seem unusual, but it's still a requirement for all employers, regardless of who their employees are. So I just wanted to mention that. But now we'll go to the questions that were submitted through the text box, and we'll go from there.
Alrighty, thank you, everyone. We're going to go until about 1:10 with questions. If anybody has to drop off the call now, you will get an email tomorrow with a link to the recording of this and to the slides. But on to the questions. The first one is probably for Liz. Is sexual harassment training required for board members of for-profits and not-for-profits organizations, as well as members of partnerships or LLCs, advisory groups, et cetera?
Yes, everyone within your organization should be trained in sexual harassment. So you would want to bring in your leaders into that as well. But again, individual volunteers or consultants don't need to be trained, but they need to be given a copy of the policy. Hopefully, that's sufficient information, but if you have any additional questions regarding that, you can just send me an email after the call. And again, it will be general information, not necessarily legal advice. And Lisa will move on to the next question.
Employers must adopt a policy that applies to outside contractors who are not employees. Should farms rely on the employer of the outside contractor for their training, or should any outside contractors conducting business on the farm also attend the farm's sexual harassment prevention training as well?
Rich, is that something you want to handle?
I can try. Again, not legal advice, but I think that if you're going to have contractors spending a considerable amount of time at your farm or in your business and engaging significantly with your employees, then you might at least provide the policy. I think if it's a New York contractor, they will also be required to provide the training to their employees. But just you are required and you are responsible to protect your employees from sexual harassment, regardless of who's perpetrating it, whether they're your employee or not. So it may be a good practice to simply provide that policy and communicate in some way that that type of behavior is unacceptable at this place of work.
And certainly having a good, effective complaint process, your employees will be in a position to let you know if they're either being harassed by someone who's coming on the farm, or that person coming on your farm or to your business is being harassed. So I think you can't rely on the other business to make sure that they're doing their training, but if that the employees have the policy, the consultants coming on your farm have the policy, I think you'll be in good shape.
Okay. Would you include harassment that does not meet the definition of sexual harassment in the policy? After all, not harassment is sexual, i.e. intimidation or bullying.
I'll jump onto that one. Yes, that's a good question, and yes, I think it's you don't want to avoid this difficult issue of sexual harassment and water it down in any way. You want to do this training. I think it's an opportunity from a practical standpoint for employers to take that extra step and, in fact, point out exactly what the questioner was saying, that all forms of harassment are unwelcome here and not part of the culture that we want to build in this business. So, yeah, because a lot of the issues that can arise, even from harassment that's not sexual in nature, are the same and just as detrimental to individuals and to the business overall, and also illegal for that matter. And so, yes, include other forms of discrimination at the same time that you're doing the sexual harassment discrimination training.
Okay, what is our responsibility if an employee claims another employee sexually harassed them over social media, specifically when the farm was not open?
I'll take that one. If you have an employee that's being harassed over social media or off the farm, and it's not technically you feel within your purview as a manager or a supervisor or an employer, that still has to be addressed, because that employee is still being harassed, even if it's not in the workplace, by another employee. So that would be something to sit down with that employee and do that investigation as you need to. And in that circumstance, you might want to gather, if the employee is willing to give them to you, the complaining employee, copies of social media posts or copies of the alleged behavior, so you'll be able to kind of make that judgment. But that would be part of your investigatory process. But again, even if it's happening off farm, if it's one employee to another, that's something that would need to be addressed, because it could impact the work at your farm. It could impact the employee interaction on your farm.
Okay, someone's looking for a better definition of what simplified training is regarding the interactive training that a minor would need.
That's something that hasn't been published at this point. It would be, you would want to make sure that the employee, especially if they're a younger person that might not have the same life experience or knowledge that an older worker might have, to sit down and talk to them about these concepts and do it in a perhaps maybe a less formal way, but not less instructive or serious way. So you have that understanding, and so they understand the concepts, but you don't have to go through all the very specific details of the policy. But again, we haven't seen what the state really intends with that. So it'll, I think, something that will evolve as the law is in place, the longer it's in place, and so forth. For example, when they put the law out, they approved the policy. We didn't have the policies in the other languages at that time. That came later. So simplified training, we'll be talking to the state about whether they're going to be putting something like that together, and more guidance for employers as well. And Rich, do you have anything to add?
No, I haven't seen guidance on that simplified version either.
Okay, we have time for just one more question. Regarding displaying pornographic material, can an employee hang inappropriate material in their lockers issued by the employer, i.e. if material is on view only when the locker is open?
Well, with something like that, even if it's only in the employee's locker, if they do have it open, it's going to be visible by other employees at some portion of time. So that would be something that I would encourage be addressed before someone makes a complaint. You can have policies that prevent employees from hanging things like that within their work area, with the argument that, oh well, it's only my office, or it's only in the part of the barn that I work in. Other employees will enter that area, whether it's or see something that's hanging in a locker. So you can regulate that sort of thing on your farm.
Yeah, and I'd like to add to that one too. And that's the sort of thing that an employer, you're probably best advised to go ahead and draw a hard line there and have somewhat of a zero tolerance for that kind of thing. Because if you don't, some employees will try to push that and will try to find loopholes and try to find ways around it. And you don't want to get into that game. You want to just eliminate those sort of things. That person, they really don't need that in their locker. They can save that for their own time at their own home.
Thank you, Liz and Richard. That was a lot of great information. We hope that everyone learned a lot today and feel better positioned to integrate this new law into their farm business. Thank you again to Farm Credit East for hosting our webinar today. Thank you all for being here today. We are adjourned.